started. Let me go back to the screen that we were just on. Hello and welcome to Navigating the Personal Medical Cultivation Ordinance in El Dorado County, Knowing the Rules to Stay Safe, presented by the Law Offices of Dale Schaefer. Today our presenters will be Attorney Dale Schaefer and Legal Assistant Heather Schaefer. We're going to go through all of the slides. As we go through all the slides, please submit questions via the Q&A feature, and if questions come up that need to be addressed, I'll ask before we go on to the next slide. Otherwise, we will address questions after the slides have been presented. We're going to tackle this information together, so Dale Schaefer will take on our next slide. And this worked. There we go.
Just a little while ago.
Yep.
Okay, good afternoon. I wanted to start by backing up a little bit, see if we can have perspective on not only California, but on the county. As you'll remember, or if you've heard about, 1996, we passed a proposition that was aimed primarily at criminal enforcement at the time. Cultivation was a felony, possession was a felony, transportation was a felony, and so people were being brought in and criminally charged for things that were just not palatable any longer. So it was passed to give an affirmative defense to the charges of cultivation and possession. Now, there have been some court decisions along the way, which we'll get into in just a moment, but there were some things that it did not do. But let's go back to when Pebbles Trippett brought her case of transportation forward. What we were able to get at that point was some definition of what it's going to cover, which included cultivation, possession, and transportation, because Pebbles had been arrested for transporting, and she asked to have the Prop 215 defenses applied to her. Now, there are no collective or cooperative defenses available under Prop 215. That was a case out of Sacramento that I was involved in to some degree, and we'll touch upon that in just a minute. And it has been narrowly construed, and by that I mean Prop 215. The criminal defenses in Prop 215 have been very narrowly construed by two California Supreme Court decisions that were asked to take a look at what rights were conferred upon patients or cultivation, people doing medical cultivation in California by Prop 215. And twice the Supreme Court has very narrowly construed Prop 215 to only apply to the criminal charges of cultivation, possession, and transportation, and it gives you an affirmative defense to those charges. Now, in 2004, the legislature had passed, the governor signed, and a law took effect, which we called SB 420. Now, this set up a collective and cooperative defense. It expanded the defenses to cultivation, possession, and transportation to cover a much broader array of criminal charges that were being brought, possession for sales, running a drug house, things like that, that had prevented Prop 215 from being fully implemented. The police were not stupid. They had figured out that people were doing more than just cultivating, possessing, and transporting. It's pretty common to be charged with possession for sales, things like that. So 420 came into existence in 2004, and it brought along the collective cooperative defenses, which we've operated in for so long. One of the issues that popped up right away was, how do we get collectively and cooperatively cultivated cannabis to patients? Well, very early on, we saw what we call dispensaries popping up in many places. And because they had been previously classified as a drug house, now there was a defense to criminal charges for classifying as a drug house. And it really started a period where law enforcement was not quite sure what to do. So now we have a stage set for the land use fight. Can you pop up the next slide there, Heather? These are the cases that brought us from Prop 215 forward to some semblance of where we are today. As I told you, Pebbles Trippett had been arrested prior to 215 taking effect, and she was transporting. So she asked to be included, and the court, in fact, did include her, and the definitions they gave us turned into the jury instruction. And back when I was doing recommendations with Molly, we gave these jury instructions to everyone. So if you followed them, it was pretty clear we could come in and defend you if you had followed these jury instructions. And it turned out that the quantity that you possessed, cultivated, or transported um, that had to have a reasonable relationship to the medical needs at the time that you were arrested. Now that turned into all sorts of dog fights, and Chris Conrad did a lot of work for quantification. I did some expert work in the area. One of the next decisions that we got was the People versus Mower. This came along in 2002, and what it did was to define who has the burdens of proof. If you are charged criminally and you want to defend yourself, then the Mower decision allowed you to raise your affirmative defense early on in the criminal proceedings. And it typically happened at a preliminary hearing, or a motion to dismiss might be combined together. And what you would do is come in with your doctor's recommendation and then have an expert like Chris Conrad raise a reasonable doubt as to whether you were growing for your personal medical needs, i.e. it was reasonably related to what you needed. And once you did that, it was up to law enforcement to prove beyond a reasonable doubt that you were wrong. Well, if you got a doctor's recommendation, they could never prove that wrong. And I know because Molly had a case that went against her at a early stage when a judge decided he knew more about medicine than she did and he was going to deny the medical defense. She got a little snippy and asked him where he went to medical school. And of course, he dismissed the case. And the appellate court said the only person in that room qualified to render a medical opinion was Molly. So they won at that point. Now, the Mike Urzasanu case came out of Sacramento, and this happened pre-SB 420. And what Mike was doing is he had, I think it was down Citrus Heights, he had a little collective grow. He distributed out of there. He had, or dispensed, if you will. He had some plants growing, and they were doing it collectively. There was a lot of paperwork floating around those days to declare someone your caregiver, and so what the court said was Prop 215 does not give you a collective or cooperative defense. No. But this case came along just after SB 420 was enacted, and they allowed it to be retroactively applied. So, essentially the case went away because, well, at least the cultivation part of the case and the distribution went away because you got your collective cooperative defense. Now, one of the important things about this case now is SB 420 is gone. So if you go back and look what the first part of the decision was, that Prop 215 does not give you a collective or cooperative defense if you're charged criminally. Okay, that is reenacted, or it never went away, but now the emphasis is that without SB 420, you don't get to collectively or cooperatively grow under Prop 215. In 2008, the People versus Minch went to great lengths to decide and declare what a primary caregiver was. And back in the day, and I'm talking 2000, 1999, 2000, around there, court decisions were allowing people who actually provided cannabis to someone to qualify as a caregiver. The Minch case said, no, you've really got to be a caregiver. You got to take them to the doctor, wipe their butt, feed them, things like that. Or you don't get to be a caregiver for purposes of the defense. The two cases that looked at the land use part of this were Raging Waters and what we call the Inland Empire case. And let me just put some context in here. As SB 420 allowed defenses for collective and cooperative growing and distributing, the inner cities got maybe not the inner cities, but urban areas got dispensaries popping up. We call them trap shops today, but they were popping up everywhere. And the planners in those areas decided, in some of these cities early on, decided we're going to go after land use zoning issues here, and we're going to declare this not a public nuisance and not allowed in the zone. Um, the Ross versus Raging Wire case was the first case that asked the Supreme Court to expand Prop 215. This was a piss test case. And Ross was he was a cannabis user, lawful cannabis user, and his boss said, well, I don't care what you are, you can't test positive and work here. And the Supreme Court allowed that decision to stand. Other states around the country have had different court decisions about that, but California has not yet. But the expansion of 215 is one of the emphases of that case. I don't like the employer-employee, decision there, but that case stands for a couple propositions. The city of Riverside case, Lanny Swerdlow, a colleague of mine, ran a dispensary down there, and they tried to zone him out. And there was a battle over whether they had a right to be there. And the Supreme Court in the Inland Empire case declined to take Prop 215 any further than an affirmative defense to cultivation, possession, and transportation, period. They can zone you out. It was commercial that they were looking at. So what happened not long after the Inland Empire case in 2013 is up in Tehama County, they passed an ordinance which restricted medical grows. And that case was challenged, and the District Court of Appeals here in our area, the Third District Court of Appeals, decided they can do that because it's a land use issue. And then not long after that, like contemporaneously, Live Oak passed an ordinance that completely banned all cultivation, including personal medical. That was challenged and it was lost based on the Inland Empire case. They can zone you out. There was no protections like we have now under Prop 64. So that there was efforts to try to get that case decertified for publication so it couldn't be cited. It didn't work. There were problems with the underlying case that I've talked to Dale Garinger about this. They were very much involved, and it was an unfortunate situation that occurred. We have an opinion on the books right now, but that was prior to being allowed to grow 6 plants per residence of Prop 64. So I'm not sure that case holds a lot of water today. When it comes to your allowance as an adult 21 or older to grow 6 plants per residence. Can you pop up the next slide, Heather? Now, Prop 215, this is the health and safety code section, and this is just a citation of what it says, and it applies in its language to cultivation and possession, but the Trippett case expanded it to transportation, and you have to have a recommendation. And back in those days, we did not have numbers. If you were charged criminally, it became a dogfight. It was an expert war as to whether you had too much. Now, Health and Safety Code 11362.77 is an ordinance or a statute that is on the books today. It survived Malcursa, which is the current iteration of our cramming together our medical laws in Prop 64. It's called the Medical Adult Use of Cannabis Regulation and Safety Act. It's hard to say it. It's Malcursa. Anyway, what the medical side of that group of regular laws has to say is that if you are a medical patient, the basic allowance is 8 ounces of dried cannabis, or you can have 6 flowering, and because it becomes important to know or and you can also cultivate 6 flowering or 12 immature. That's sort of a floor at the state level. As far as defending yourself from criminal charges. It doesn't seem to have any effect on these land use ordinances. And this also is attached to a state ID card possession allowance that before we have these current laws, if you had a state ID card, you couldn't be arrested if you had these amounts, okay? Um, that has survived into the latest iterations of our cannabis laws in California, and there's been so damn many of them, it's hard to keep on top of them. Now, one of the reasons I put this up here is because there is an enabling statute which allows counties and cities to retain or to enact guidelines that exceed these amounts. Okay, now that gives the authority to a local jurisdiction to go to these amounts, but you don't have to have these amounts. It's not required. It's authority to do that. It's not mandatory. Can you give me the next slide, Heather?
We have a question, so I'm going to allow
Okay.
Al C to talk.
Okay.
Al C, you need to unmute yourself. Al C, if you can hear me, you need to unmute yourself. Oh, he put his hand down. So we will go to
the next slide.
Next slide. So this brings us to the El Dorado County cannabis cultivation allowances that exist today after the changes to the ordinance. If you planted or began your operations for planting before May 6th of 2020, you are allowed 200 square feet per patient with a maximum of 3 patients per parcel under zoning as follows. If you are at lots zoned R1, R20, 000, R1A, R2A, or R3A, you have a maximum of 200 square feet. That means you can only provide for 1 patient on those zoned parcels. If you are on lots zoned RE and RL, you have a maximum of 400 square feet, which means you could have 2 patients at 200 square feet per patient on those parcels. If you're on lot zoned AG, FR, LA, and PA, you would have a maximum of 600 square feet, which is the maximum allowance within the old ordinance or the current exception to the ordinance. So 200 square feet per patient times 3 patients on that property. You must be able to prove that plants were planted or started prior to May 6th of 2020. You also must follow everything in the following rules. Now, if you had not begun your planting or your operations for your medical cannabis cultivation grow before the 6th or the 5th of May, or 6th of May, excuse me. So after the 6th of May, then you are allowed 6 plants per parcel, and you also must follow everything in the rules. Did you want to add anything?
Yeah, I do. The ordinance actually says commence cultivation. Now, as attorneys, we really don't like when new words are thrown out at us that aren't defined or new terms. Commencement of cultivation, I can think of a lot of things that could mean. A plant is not a plant until it has roots, and if it has roots, hasn't been planted. I don't know where we're going to parse this out. One of my early recommendations was that you take pictures of plants that are growing independently and try to date that. And if it's in the ground and you got a picture and you can date the picture, you should be golden. That would be the highest level of evidence, but it doesn't mean you have to go stick your rooted clones in the ground before they're ready, or you've got to take plants out of pots where you're trying to weatherize them and get them accustomed to the climate and put them in the ground yet. But if they show up to do an enforcement action, I've got it on pretty good authority, they're going to put a microscope on the rules and what you're doing. So if there's any reason to believe that you did not commence your cultivation before May 6th, then you better be prepared to establish that you did. And we found out yesterday that they've done their second flyover. So I don't know all of the abilities of this particular satellite, but if a roofer can estimate the size of your roof from a satellite picture to give you a contract, then if I'm a betting man, they can come pretty close to figuring out if you have 2, 4, 600 square feet, especially if it's outside. If it's in a building, it's a whole different equation. I just want to caution people to take some steps to try and document that you in fact had commenced cultivation before May the 6th. Otherwise, you're at 6 plants. Okay.
So that leads to the next question, which is how would you determine your zoning? So you can look up your APN number by going to parcel.edc.gov.us and search by your address. Write down the 12-digit number that's provided once you search your address, and then you're going to want to go to search the parcel data information. And here's the link available to you right here. You would enter the first 8 digits of your APN into the search box and hit search. Search the parcel data information, and what you're going to be looking for is your 2015 zoning information, and you're looking for the box entitled zoning designation, and that will have your most recent zoning of your parcel, which is the most accurate. Attached on our website, there was also a link not only to this webinar, but there was a link to a folder, and in that folder is a document that has the links that go directly to these 2 locations on how to look up your parcel number or your APN number by your address, and then how to search that APN number to find out your exact zoning information. Moving on, following the rules in El Dorado County, if you're planning to cultivate medical cannabis in El Dorado County, you need to pay attention to the following areas to be in compliance. And these are the basic areas of the rules over and above whether you qualify for square footage or if you qualify only under the 6 plants. You're going to want to pay attention to screening, to security, to the distance from youth-orientated facilities. You're going to want to pay attention to setbacks, to residency, property owner authorization, environmental requirements, disposal of waste material, contact information, and odor. And we'll go we'll dive into these a little deeper as we move forward, but that's the overview of what you're going to need to be paying attention to. So for instance, screening. Cannabis shall be screened from public view so that no part of a plant can be seen from an adjacent street or adjacent parcel. Any greenhouse, hoop house, glass house, conservatory, hot house, structure, fence, or material used for screening shall comply with all building and zoning codes and any other applicable law or regulation. Do you have anything to add there?
Well, it's the building and zoning codes that could be the tripwires here, because there are avenues to get on your property through what we call an administrative warrant. And if there is in plain view a violation of building or zoning codes, a code enforcement officer can seek an administrative warrant to come in and look to see if in fact there is violations there of building or zoning. And what I think you should expect around the county, not necessarily medical folks, but you should expect for multiple layers of jurisdictions to come in. And we're talking fish and wildlife, water. We could have law enforcement involved. There are some things going on out there in the illicit commercial world that they're trying to curb, and some of them involve environmental issues. There's pesticides, there's chemicals, they're poisoning wildlife, there's sediment and things leaching into the soil. So these violations could be your bigger problem than growing weed. And I saw that Ellen had a
Ellen Comp from Cal Normal has a question. She wants to know, does El Dorado County have building or zoning codes governing greenhouses? And the answer to that is yes. I was recently told by the building department that it's going to require you to have a building permit on structures that are larger than 200 square feet, and that although you may qualify for a bit of a skip in the process, because if it's an ag zoned, like if it's an ag building, you might not need to or be required to get the inspection process through, but you will need to file the application for a building permit, and you will also need to pay the fees for a building permit. Moving on to security. The premises on which medical cannabis is cultivated shall utilize legal security measures, including but not limited to being secured by a minimum 6-foot high solid wood or chain link fence with locked gates built in compliance with building and zoning codes. Keep in mind that a chain link fence is not sufficient for screening if it doesn't have the slat coverings. You need to not be able to see through to cover the screening portion of this rule.
Well, and screening is different from security.
Correct.
Just because you have a fence doesn't mean that you have it screened. And if you're going to have security, if you got a fence up that you can't see through, they're going to want it locked so that someone who's not old enough to be using cannabis or who doesn't have a recommendation or both can't get in there. That's another part of the security. You can basically chain it up, lock it.
Correct. Distance from youth-oriented facilities. The outdoor cultivation of medical cannabis shall be located a minimum of 1,000 feet from any school, school bus stop, church place of worship, park, child care center, or youth-oriented facility. The distance shall be measured in a straight line from the closest boundary of the premises on which the medical cannabis is cultivated to the closest boundary of the premises on which the school, school bus stop, church, park, or youth-oriented facility is located. Now, for some of you that live in like in a town or in a small town, this might, it would make sense, if you're close to, a school or a church or a daycare center or, a karate center or someplace like that. But I'd like to give a heads up to the people who live in the rural parts of our county, because those rural bus stops also count as youth-oriented facilities. And so you want to make sure that there is 1,000 feet from those as well.
Well, and it's outdoor cultivation. It's not that you can't cultivate, but if you're close to those facilities, then you don't get to grow outdoors. And there's some restrictions on the 6 plant cultivation outdoors also with respect to some of these youth-oriented facilities. It's not just personal medical cannabis. It has to do with outdoor growing.
Correct. Setbacks. The cultivation area shall be set back from all property lines no less than the following. For lots zoned R1, R20, 000, R1A, R2A, and R3A, there is a 50-foot setback from each property line. For lots zoned RE, RL, AG, FR, LA, and PA, there is a 100-foot setback from each property line.
Okay, residency. Um, I'm not sure people who have been growing are going to like the residency requirements that the county is going to impose here. It prior to the change in the ordinance, it was possible to have one of the people, either a caregiver or one of the patients, to be a resident on some of these more rural types of lands farther away from people. Uh, they want a primary residence to be for the person that's either cultivating uh, or the caregiver that's cultivating for them. Now, and you basically you can't grow on land that doesn't have something living on it. Number one, so if there's not a residence on the property, then you don't get to grow on it. Okay, and if there is a residency on the property, then either the sick person or the caregiver for the sick person and the sick person have to live on that property. Okay, and I've got it on pretty good authority. They're going to be looking carefully at this. It's one of the areas that has caused problems in the past. Um, I mean, problems in the eyes of the county, if you will, not so much for the people growing it, that they were growing on, maybe there was a residence, but nobody that was sick or a caregiver actually lived in the residence. They were just leasing it out. Okay. That's one of the things that got Officer Ishmael murdered. So they're not going to be given any room on this. Okay. Now, the definition of a caregiver, again, they're reciting back to the health and safety code where you really have to take care of this person. And if it's, say, your spouse or a kid, or you're taking care of your parent or something like that, that's the ideal situation. You're the caregiver, you're taking care of them for real, and they use cannabis. You can then be vested with the ability to grow for them as a caregiver. That should all be okay. If that isn't the situation you're in, then you may have some issues with the county if they show up. In fact, I'm telling you, you are going to have issues with the county when they show up. Next slide, Heather. Now, this is also going to cause some issues for people in the county who are personally growing, because there have been arrangements made with landowners to allow grows on their property. Okay, wink, nod, handshake, things like that. Again, that was one of the issues that got Officer Ishmael murdered. It was a lease agreement to Mexican cartel. Okay, so if you are going to grow on property that you don't own, you're going to need to have a notarized authorization from the landlord that you can in fact grow cannabis on their property. Now, if you own the property, that shouldn't be a big deal. We have a form, or we can. Do we have one of those forms, Heather? An authorization in our
We in the folder that's linked on our website, we do have a property owner authorization form that allows for the property owner to state that they are giving you permission, and it's already set up to take straight to the notary for the notary to notarize the signature.
It's a form we use in the commercial cannabis space because it's required at the state level. You got to have landowner authorization. Now, this creates some troublesome issues. One is that if you have a mortgage on a piece of property and it's a federally insured mortgage, this is a Schedule I drug. Creates all sorts of problems. And if you have a problem growing that leads to a loss on the property, odds are the insurance company's not going to pay for it. In the commercial cannabis space, we have run into this situation where somebody had a lease on a property to grow cannabis or to have some cannabis business there. And it turns out that the people who held the mortgage were not going for that. It was not going to happen. So there are some delicate issues here. Again, if you own the property, we have a form. Get it notarized, have it part of your packet. If you don't own the property, now you need to be having a discussion with your landlord. And if your landlord's not good with it, and you've been growing without your landlord permission, this is not a brand new requirement. this is not just put in, that you've needed to have your landlord's authorization all along. They're just going to now get very persnickety about following these rules. And if you don't have your landlord's notarized authorization and they show up, then it's 6 plants per residence. Okay. And this has ramifications for the landlord in other ways too, because there's a remediation requirement in this set of ordinances. And if a landlord is going to claim that I don't have any responsibility for them growing there, they're going to have to establish that they weren't in the area, that reasonable observations or going by and checking your property wouldn't have put them on notice of this. Okay. So that's what they're going to have to prove. But that doesn't take away their responsibility for any of the other environmental crimes that may have been committed on that property or environmental effects. The landowner is going to have to remediate that property back to its pre-cultivation status. And I don't know if I've seen this around where a bulldozer comes in and flattens off a pad. They don't put in proper drainage around it. They cut trees. I mean, and they just let sediment go into the waterways. There are just myriad problems that come from this. There are some groups that dig a hole and use it as their restroom. Okay. It's certainly not going to be allowed, and the landowner is going to get stuck with fixing all of this. So I think everyone can imagine a landlord that says no, and now what are you going to do? Okay. I don't have an answer for that, but without that authorization, you don't get to grow any plants, because even the 6 plants for someone who doesn't own the property is going to require a landlord authorization. Okay. And again, they're going to look at this very carefully. Okay. So next slide, Heather.
Valerie will address your question after we're finished with the slides. That's the first one I'll go to.
Now, the environmental issues are what are killing us in the commercial world. And it's going to be the same in any cultivation of cannabis, whether it's 6 plants or it's your personal medical that's going above that. What we have seen is that my grandpa used to call them dog knots. People, and he built them. They would hammer stuff together, set stuff up, make it work, but none of it was really totally legal. You're going to have a legal source of water on your property. And typically this is a well, unless you're up to a water district that provides water to you. Okay. You can't just be bringing water in, or more importantly, you can't illegally sink a well or tap out of water around you. It's not going to be allowed. The water board has no sense of humor about this kind of stuff. And if it turns out that they find you doing those things, then they're going to be alerting the other authorities. And some of these are felonies. So, be very careful. Make sure you have a legal source of water on your property. You cannot take water from flowing waters or lakes. This became a major problem over in the Triangle, where people were tapping the streams over there and the fish couldn't even spawn anymore. That's going to be another one of those water board issues. And what we're experiencing now in the commercial world is you start drawing too much water. Of course, your neighbors can say something about it. That's not the county coming in after you, though. You can't have water running off your property. When we have the water boards come in and look at our projects, you have to look at the amount of disturbed land involved, because that is how much sediment potentially could run off it with normal rain. They're going to be looking at this, because if you do what I've seen a lot of, is just a cut into a hillside without proper drainage around it, you're having all sorts of dirt and other sediments go into the water as it runs off your property. And not only do we have to pay some extra as a commercial cultivator, depending on how much land we've disturbed, if you don't have proper permits and you've done these things illegally, this starts stacking up potential criminal charges and at a minimum, you have to remediate this back to what it was. So um, it's one thing to take a D8 in there and cut a hillside. It's something else to come back in and restore it. The chemical issue is one that most people haven't really had to deal with. Um, when we deal with chemicals in the commercial world, they've all got to be properly labeled, properly stored. You've got to have a material data sheet, okay, that tells you what's in it, how to store it, how to handle it, what do you do if you're exposed to it, what if it catches on fire, okay? And you need to know what chemicals you have on the property, especially those that have anything to do with cannabis. A lot of people have their special formulas, how they take care of pests, how they, put nutrients into their soils. But if that is leaving the property somehow, it's drifting off because you're spraying it, or it flows off in rainwater. Okay, these are serious environmental charges that can be brought against you. So go look at what you are using chemical wise. If you bought it from a commercial store and it's still in the container, it's easier, but you should be able to go back to where you got it or go online and request a material safety data sheet. And they can give you access to it. You download it and print it, keep it there, but read it. If it's got to be stored in a non-flammable container, like a metal locked cabinet, then you need to do that. I don't know if any of you saw what happened down in Los Angeles, where the fire guys were inside a building when butane went kaboom. Okay, I've got firefighters in my family, and they like to know what they're getting into. So all the commercial properties we deal with, the fire marshal has to come out and sign off that we have complied with this, so they know what's on the property. They know what to expect when they show up. Most people that are residential livers on property, you go to the hardware store and buy stuff. You don't think about it, but they're going to require that you pay attention to what's in it. And if you put it in another container, you're going to have to properly label it so they know what it is. All right. And you're going to have to store it. And you may need to understand what it takes to put a fire out if that catches on fire. So these are some pieces of information we're happy to continue to chat with you about as time goes on, but you should be thinking along these lines. Now, the county, the ag commissioner should be able to help you with a list of banned pesticides, fungicides, and fertilizers in the county and the state. Okay, we don't have one here. Heather could probably help you find it. We know the ag commissioner fairly well. They know what you can't use. And you need to understand what you can't use, because if they show up to count your plants and you've got an illegal pesticide there that they can see, things are not going to go well for you. Okay. So you need to know what it is you have. And if it's banned, then properly dispose of it. Okay. Because if you're going to do this and have them on your property looking around, you don't want to have, I told my kids, don't break more than one law at a time. Okay. So be careful. All right. Give me the next slide, Heather. Okay. The water systems in the state have been taken over as a state resource. So they get really upset when you just dump things. If you are going to be discharging liquids on your property, it needs to go into a proper sewage system or a septic system where it's properly permitted. Leach fields are there. If what is coming off your property can get into the groundwater, there's going to be problems there. And there have been lots of reports of grows where we've had a large group of people there for periods of time living in tents or things like that, and they don't even have an outhouse. There's just, it creates a lot of environmental problems. And if you're the landlord, you may be out there fixing that. And if you're not, you may still be out there fixing it. Now, what I just went over with you is about labeling these pesticides and fertilizers. If it is legal to have it, and it's not in the original container, then you might want to consider getting rid of that. Okay. If you know what it is and you can properly label it, then try to find that safety data sheet information to make sure you know what it is, how it should be used and stored. Now, the wildlife poisoning is one of the other issues that the enforcement folks are going to have, because out in the sticks, especially where deer can come in, or other animals can come and eat your weed, people poison them. And they're not the kind of people we want to be working with and associated with, but it does happen. So they're looking for evidence that you've been intentionally poisoning wildlife. If it's a negligent poisoning, you're still going to have fish and wildlife problems. But if you're trying to kill them to keep them away from your crop, now you're looking at potential felony charges. So be very careful about this. Now, power has always been an issue. And for indoor cultivators especially, they used to be found by having their electric meter spinning, and someone would report it. Then they started stealing it around the meter so they wouldn't be, reported, but they still got it. Okay, you are going to have to demonstrate that your property has a legal source of power. Now, it's been a long time since I've been out to a real off-the-grid rural place where you may not have the kind of power they're talking about here. But if you have power coming in, and it's and PG&E, say, is what takes care of power up here. If you got PG&E to your property, okay, you got a meter, they can monitor that. You're not stealing power. If you have big generators, though, these become some issues. I don't know where they've drawn the line with non-commercial. With commercial, it's 50 horsepower, I believe. And in the commercial area in Dorado County, you've got to pay carbon credits. I don't know exactly where this might go, because if you don't have a legal source of power, I'm not even sure what to tell you if they show up. It depends on how you're producing the power there. If it's a generator, things like that, then they're going to look for how you're storing your gas. Is it dripping on the ground? I mean, there's a lot of things that they can get really nitpicky about. So this is an issue that I don't really have a good answer if you don't have that legal source of power. I guess we'll just have to deal with some of those as they come up.
Before we move on to the next slide, there is a question about fertilizers. What if you're using natural fertilizers from live animals?
You mean like bovine scatology?
I believe that's it.
Okay. Well, those are naturally occurring you can compost. There are rules about composting. You can use fertilizers. They're used commercially. If that's the source of it, then label what you've got. If it's in a container or something, label it. If you're still making it, composting it, just be prepared to explain what you're doing. I don't think that's the issue. The problem that they're seeing is to accelerate growth and to stop pests. They are putting chemicals on the plants in the commercial world. So the code enforcers and law enforcement are looking very carefully at this. If they show up and see you with unlabeled illegal chemicals, there's going to be some explaining you're going to have to do. And, you may be able to grow your 6 plants or your 200 square feet, but no, you won't get it because you won't qualify. As soon as you don't qualify for everything on this list, you don't get the 200 square feet. It's only 6 plants. Okay, next slide, Heather.
Okay. We do have a hand raised, so.
Okay.
Valerie?
Unmute.
Yep.
She's muted. Is that you or her?
There we go.
Okay.
Go ahead.
I didn't know we were going to talk. I just asked you. I posted that question on the site. I typed it in. You said
we'll get back to you on that question at the end of the slideshow.
Okay, so then let's lower my hand because I didn't realize my hand was raised.
Oh, okay.
Party foul, Valerie. Okay. I do too. I can't even turn the damn thing on, so I get it. Okay, the next slide is about the disposal of waste material. Now, if it's an illegal substance, it's a chemical, things like that, you need to be very careful. El Dorado County has lists of what you can do with different chemicals, how you dispose of them. Okay. In the cannabis sense, the waste material that we deal with in the commercial world is primarily stems and stalks, what you might call cheap hemp. Okay. Composting is what we recommend for the smaller cultivators, and that would be my recommendation. You compost it. Okay. There are regulations about composting, but they tend to deal with commercial composting. And composting is actually kind of fun. If you can find different materials around your property, green waste, brown waste, you know, manures and things like that, and put in your cannabis waste, grind it up and mix it up in there like compost. It's actually a good way to keep it out of landfills and put it back into the earth. Now, you're not allowed to burn it. And this is the same in the commercial world. They're trying, you know, to find something to do with this besides put in the atmosphere. Some counties allow it to be composted in a bigger sense, and that's our preference. So if you could do that, fine. Otherwise, there are, El Dorado County has a closed waste system. I mean, they have one group that does it. They're granted that permission by the board, blah, blah, blah. They have a green waste pickup. It could conceivably go in there. We've met with them. I don't think they have a huge problem. We put it in there. They're just going to compost it. So you can do that yourself. If you're lawfully growing it, you shouldn't be afraid to put it into your green waste bin. But you can grind it up and, you know, make compost out of it. Okay. Next slide, Heather.
Contact information. Okay, so the names and contact information of all individuals residing at the parcel who are responsible for the cannabis grown shall be posted at the site of cultivation and made available to enforcement personnel at the time of any inspection. So in that folder that we have linked on our website is also a document that's very easy to print and fill out for contact information. And this is something that we deal with. Local contact is something we deal with on the commercial side as well. They just, it's probably a good idea to have that up at the cultivation site where you would, right next to where you would normally put like your garden notices and where you put copies of your recommendations and those types of things. Odor. You want to take this one?
Sure. Right now, we can't figure it out what it means when they say odor. We just had a meeting with planning yesterday, and they couldn't explain it to us. Our people who do our CEQA evaluations, they can't explain it either. They want odor control, and we're going to try to get to the bottom of that. And what I'm assuming is the offensive odor, if you will, is in the terpene category. And it may be some other combinations of chemicals, but the skunky smell is what seems to get them. Now, we're trying to figure out from our chemists who go out and do these detection levels, to actually set a machine up and bring air through it, and it'll tell you that you have spikes in certain molecules, and they use a number here of 7 DTs. Now, my undergrad was in a lot of science, you know, through organic chemistry. So the questions I have that I think will be logical of what molecule are we talking about? What are we measuring here? You know, we'll get back to you. So what I'm telling you is that if there is a complaint that there's an odor leaving your property, okay, they will set up a machine and take 2 tests in an hour and see if the levels are above 7 DTs. And if so, you may be asked or required to take odor control measures up to and including carbon scrubbers. Maybe you have to go inside. I don't know how they're going to enforce all of these or even what their detection levels are. I can just tell you this is something we're grappling with right now. And I try to remind people that when I drive south on Interstate 5 past Terrace Ranch, and as my eyes are watering, I suspect we're more than 7 DTs there of something as I'm driving on the freeway. But it's looks like it's an ag cow county, so you get to have ammonia from bullshit around you, but this one we're not sure. Okay, so we're just alerting you to the possibility that there could be some odor problems. They could cause complaints, which gets them out to deal with you. You may have your 6 plants or your 200 square feet, but it may not be the end of the discussion. And if you do have odor problems, you could lose your ability to grow beyond 6 plants also. You got something to add to that, Heather?
And the county may require or suggest the installation. The county may require or suggest the installation of one or more odor control options, which could be, include but not be limited to activated carbon filtration or equivalent types of carbon scrubbing in order to reduce the odor that's coming from your plants if they're inside of a hoop house or greenhouse. And of course, it's a little bit harder to control it if they're full outdoor grown plants. So again, that's where, like we were saying, they may require you to reduce or abate back to a smaller number in order to reduce the odor.
And since this is an enforcement stop until December, it's only for this year. So if you get an odor complaint, I don't know that you're going to have, realistically time to bringing this to your attention because it's one of the factors that can cause you to lose your ability to get more than 6 plants per residence. I just don't have an answer for it. I wish I did. And these things that were listed there, we're doing on some of our commercial properties right now. We're having to price greenhouses that have the ability to have layered carbon filters in them so that there's no smell. Okay, and it's not cheap. Okay.
Records that should be kept. We are recommending that you are posting in your garden a medical recommendation for every patient. If you can prove that you planted or began the process of planting prior to May 5th of 2020, garden notice and your local contact information. In your records, we would suggest that you keep a copy of the medical cannabis cultivation basic rules, which is attached in that folder that's linked on our website. It's in those documents, as well as a printout of the zoning of your parcel and the owner's authorization if you're not the owner of the property and you're leasing the property or renting it, as well as we've provided for you data sheets on your cultivation. And the main thought about those data sheets is as we all watched the meetings with the Planning Commission and the Board of Supervisors where the Sheriff's Department stated numbers of or amounts that is coming off of plants, if there was disagreement with that, these data sheets would allow you through filling them out to provide information like what strain you're cultivating, say the date you planted, the date you harvested, and then the weight of say what you harvested, and separated into flower and trim and waste, so that there's you're keeping accurate records of what it is you're cultivating and how much was provided and how well that did or did not provide for your medical needs throughout the year.
One of the other reasons that I would like to see the data is because this is going to expire in December, but it doesn't mean it can't be renewed or brought back to the board. And I have seen plants that are 20 feet tall. I have, so I can't say I haven't, but I showed pictures to the board of Charlotte's Web, little kids stand next to them. And if what you need is in Charlotte's Web, then the 20-foot plant is not the metric to apply to you. So I believe in facts and figures and data. Molly and I were doing the same thing 20 plus years ago, because when we first encountered the sheriff, it was less than 6 plants. By the time we had our meetings, we got guidelines of 10 flowering, and you could start 20. Now we've come full circle back to a point where we're going to go back to 6 plants, and there's an express belief on some of these policymakers or enforcers that each plant's going to produce 10 pounds, you get 60 pounds. And I'm not saying that's not possible, okay? But for people who are medical patients, we'd like to know what it is you're doing with the plant. If you grow a plant and it produces 1/4 of a pound, and that's biomass to make something for seizures for your kid, that's a whole different dynamic than if you just like to every once in a while smoke a little pipe full for your anxiety. So we would like to be able to bring information back to the board at the end of this grow season that's as complete and as trustworthy as we can. So we've got those available. If you'd like to continue to work with us, we're happy to do that because data is what's going to ultimately win this argument. Okay.
Ellen was just contributing to the conversation that we should mention that the exemption expires in December unless renegotiated, and that it would go next year, the 200, 400, 600 foot exemption would not apply. It would go straight to 6 plants per parcel, no matter the number of residents that or patients that are living on the parcel. Thank you, Ellen.
Okay, how are you going to be notified? Well, they're already starting to do mailings. We were told yesterday by Creighton that the mailings are started. They did their second flyover. So they will mail a notice of violation and to abate to the landowner. They can also come put it on your gate and give you immediate notice. Mail notice typically comes with some mail time before it becomes effective and is served. I didn't see those kind of distinctions in their notice that get sent. But once you have been officially notified, now you got a 96-hour clock running to abate, but you've only got 3 calendar days to ask for a hearing to try and deal with what they're saying you're out of violation and you've got to abate back to. So I will be doing some more research on that. I get an intern starting Monday, and that's going to be one of the things he's going to look into for me is what are the procedures now? You shouldn't have to hire a lawyer to do this, honestly. I mean, not that you won't for some people, but there's a form you file. They should give you notice of that. If we can find the form, we'll try to get it up on our website and some of the procedures and what issues can you really raise at these hearings. Now they are coming on your property through aerial surveillance. Now this is primarily going to be code enforcement because plain view from a lawful vantage point includes a satellite image. And the reason they got this satellite is because it can give GPS coordinates. It can identify a parcel. And as I said earlier, a roofer can give you a roof estimate from a satellite image. So I'm fairly sure that they can figure some things out here. So if there is a flyover that sees you are out of compliance, then you're going to get a notice somehow, whether it's stuck on your gate, it's mailed to your landlord, mailed to you, and then you now have 96 hours to decide what you're going to do as far as cutting your plants back, and a much shorter window if you have something to say about a compliance issue that you may be able to address. Okay. Now, when it comes to the exemption that's going to expire in December for this growing season, I'm not sure how successful all these are going to be, because if 96 hours goes by and you don't have some answer yet, that's where things begin to get dicey. Because if you have 200 square feet and more than 6 plants, and you got 96 hours to abate, and you're rolling the dice that I'm going to go have a hearing and doesn't go my way, I'd like to know that you're not going to get fined $1,500 a day per plant if you lose. That's some of the things I'm going to try to get some answers to, because ultimately the fallback position for plants is, if you're not going to get the 200 square feet, you cut back to 6 plants, pick what they are, you get time to do that. No harm, no foul, as they say. Problem is, when they're on your property, plain view from a lawful vantage point means anything they see can then trigger immediate action. If they got the sheriff with them and they see evidence that you are doing something that they believe is a crime, they're seeing with their own eyes, then now exigent circumstances, maybe they have a judge standing by to call for a warrant, say, we've seen these things, we want to get a warrant issued and we want to go in further. I don't see that as big a problem for personal medical growers. Okay, but if you're trying to, roll the dice this year and think, I'm going to try to be well above this, and if they show up, then, maybe I'll just cut back and it'll be okay. Understand the risk you're taking. Okay, so let's get the next slide here, Heather. The fines are draconian. Okay, if you don't have a doctor's recommendation, if you don't have your landlord's permission as a minimum, and you don't cut your plants back within 96 hours, $1,500 a day per plant is the fine. Okay, now if you're renting, who's going to pay that fine? Is it attached to the land, or is it attached to the cultivator? I think because they're going through code enforcement, they're going to stick it on the landowner. Now, this has been problems in Sacramento. They did something similar, and they got a judge to stop it because there was a problem with due process for a landlord who was absentee, and someone rented property and was growing lots of plants in there. And they tried to tag large fines on them, and the judge wasn't going to have any part of it. Now, there is a due process component to this. If someone's going to say you owe $1,500 a day per plant, then you're going to get a hearing on that. You have a chance to contest that. But if you lose, there's no upside to this. Okay, it's all downside. And this is not going to be an issue for personal growers this year, but if you have a second violation in 12 months, look, it goes to $2,500 per plant, and a third, it's $5,000. Well, you're going to get one shot at the apple this year for personal medical grow, realistically, and you're not going to get a chance to replant. So it's probably the top $1,500 fine that you're looking at. If you fight this and you want to fight them, the downside is that's what it could be if you lose. Okay, next slide, Heather. Now, this is the sort of this issue I have with 96 hours to abate, but you only got 3 days to request this hearing. And what I'm not clear on is they mail it to you. Typically, we get 5 days for mailing in the Code of Civil Procedure. If I mail something to you, it's not effectively served on you for 5 days. I don't see reference to that code section, so it's one of the things I'm going to ask my intern to go look at this for me, see if you can get us some case law or something else so we can know what to do here. And can you be excused from the 3 day if for whatever reason you didn't get actual notice? Because constructive or legal notice is different than actual notice. So we'll continue to look into that. Now, once you ask for your hearing, you get it in 5 business days. They're going to set this up and do it pretty quickly, theoretically. But I don't know if they have any mechanism set up to do, to someone appeal a code violation. I mean, it really has not been a big problem. They only had 2 code enforcement officers in the county up here. And now they're going to need a whole lot more. With only 2, you can't imagine there's hundreds of cases a year that are going to these hearings. So to have it stated here that you get a hearing within 5 business days, you know, I've seen the games be played in the civil courts where we really can't do it. So someone runs down, stands in the court and says, I'm here, and that satisfies it. And then they make you wait until they can actually get you a hearing date. I don't know. I've just seen some games be played with this, but this can be something that's important if you really think you have a right to do what you're due and you miss any of these dates. You could lose your right to actually appeal and to try to keep your personal medical garden. Now you get 5 calendar days after the hearing, you get a decision. So it goes fairly quickly. 3 calendar days to appeal, 5 for the hearing, 5 for the, 2 weeks, and you got a decision. And if they abate any of these fines during that period while you're in good faith trying to, fight it, okay, we have to deal with this in court all the time. If you challenge something and lose, sometimes they retroactively spank you. I would hope it wouldn't happen here, that you have an abatement of these fines as you're reasonably trying to figure it out. And then you get notice you've got, X number of hours or number of days to now abate without, incurring these fines. Okay, next slide, Heather.
Okay, so things to keep in mind. A link has been placed on our website, like I've said, with the following documents: a consent of owner. These are blank documents for you guys to fill out. A list of basic rules addressed in this webinar. Local contact information sheet. Again, that's a blank one that you can fill out. A sheet giving you directions with links on how to find your zoning, garden notice, and the medical cannabis data sheets. If for some reason you felt like you wanted or needed to set up a 30-minute Zoom meeting with us to discuss the specifics of your property, and you wanted to have attorney-client privilege, say, attached to that, you can feel free to give us a call at the office, and that's 530-320-4191, and we can set that meeting up for you. For anyone who might have missed this webinar, a video of the information will be on our website by the end of the weekend. And of course, the webinar is free. This information is free to all patients, but if you feel so inclined, there's also a donation button on our website, and we're accepting donations through that. Also, if you need to update your recommendation, just like everybody else who's really trying to push, finding and going to local businesses within our community. For El Dorado County, Cool Consultations does provide recommendations, medical recommendations to patients, and we highly recommend them, and they can be contacted at this information. That's area code 530-888-9020, and it's managed by Bobby and Daisy Eisenberg, who are great. We're longtime friends of ours. This is a wonderful location. Coolconsultations@gmail.com or www.coolconsultations.com. You can find them and set up an appointment immediately. You're going to need a recommendation if you are cultivating above 6 plants. And then for us, if you need to reach our office, we are the law offices of Dale Schaefer. Our address is 4010 Foothills Boulevard, number 103 in Roseville, 95747. But we're practicing traditionally out of El Dorado County, and this is, a mailing address. We can be reached at 530-320-4191 or daleschaeferlaw@gmail.com. You can find our website at www.daleschaeferlaw.com. On Facebook, we are at Dale Schaefer Law, and on Instagram, we are at Dale Schaefer Law. So
I can't get to any of them. I'm IT challenged, so.
At this time, let's go to questions. First, we do have somebody with their hand raised.
I thought we were going to do Valerie first.
We're going to,
Am I here?
Well, you're there, Valerie.
Hi. Hey, listen, I want to thank both of you for everything that you're doing. I think is wonderful, and you deserve a lot of credit. So thank you for all you do. I did submit a question, but let's pass over that question. I want to talk about where I am. I'm very, there's a fox outside. I'm very remote, and I have no neighbors. And I'm on my own well. I do everything organically, and I do everything legally. I've been doing it for 5 years. I see Bobby. I post my sign up. And I've noticed that the helicopters have not been coming around. The first couple of years I lived here, they were, and dipping down, looking, and then about 3 or 4 years they stopped, and then this year they're coming back again. And then somebody posted on nextdoor.com, they saw a SWAT team right around our four corners by the Somerset Bucks Bar in Pleasant and E16, down very rural by Grizzly.
Mm-hmm.
So there's action around. So my question is, say I still doing everything legal, okay? And they get curious, and are they just going to show up on my property? Or are they going to give me a call for an appointment? Or are they going to send me a letter if they want to come and look? How does that happen?
Well, they're not going to be asking permission, okay? Because we have an ordinance that declares certain things to be a public nuisance, and it gives code enforcement a right if they see a code violation from plain view, and the satellite is plain view. So if they fly over and see that someone's out of compliance, then they can and will send a notice to you that you're out of compliance. And if they want you to abate, they can put those two notices together.
So they won't just show up to your house and say, I want to see what you're doing.
They could, because if there's a code violation, they have a right to go get what they call an administrative warrant.
Okay, but if there isn't a code violation and they're just curious, and they can kind of do what they want sometimes and flake it over.
Well, if they have no right to be on your property and you didn't consent to it, then they're trespassing.
Okay, because I do everything legal on the outside, but I don't want these guys to just, have any reason to say, say they said I had one plant too many because it went over 200 square foot. Okay, so I kill the plants. Do they going to come back a week later and see if the plant is in a grow tent in my spare bedroom? I mean,
well, now you've got theoreticals that, there's millions of them. This is why, attorneys fight warrants when there's criminal charges behind them. These are administrative charges. And in most cases, it goes no more than, you took care of the problem, have a nice day. But these are some unusual times, Valerie.
That's what I mean. Well, that's what I mean.
I would like to tell you it won't ever happen. But, we're hearing stories around the county right now about enforcement actions taking place. And what I'm trying to gather is factual information about how it was done, who did it, whether there was warrants shown, warrants left, anything left on the property to, to show that we had a lawful right to be here. Not that I'm going to be the one fighting these, but I'm trying to figure out how they're going to enforce this. It looks like code enforcement is the easiest avenue if they have a satellite image. Now, just so you're aware, if they're on your property lawfully, okay, if you are out of compliance anyway, and they see anything that's unlawful, well, okay, that allows them to pursue that.
Right. Okay, so, I understand. But I wanted to say something. So say we get our ad hoc committee, and I try to get as many medical people that really need to grow as much as they can, or they're going to run out of medicine. They can't afford to go to the dispensary. Like Ellen said, power in numbers, and get that ad hoc committee and see what we can accomplish by December when this whole thing runs out. And if we can get, a need and show that people will come and like me, I'm standing up and I'm saying, yes, I need it. And this is my medical condition, which that's a private thing. It was really hard for me to do. I've never done that in 35 years of my illness. I have never come out. So that was a big step for me to do that publicly at that meeting that I know was recorded and on YouTube. But anyway, so what about this? So say they take it away from us. So can't you just, if you're a grower, you know what you're doing. You tote a 600 square foot smart pot and you grow 6 monsters, you will have more pot than if you grew in your 200 square foot. So is that legal? Because it's six trees. That's what they say, 6.
Yes, it is.
So somebody knows what they're doing.
Yes, it is.
Somebody knows what they're doing. You're going to grow more pot than you're going to get in 200 square feet.
Well,
right?
Understood. And if you are in a zoned property that allows outdoor cultivation and all the other, list of things we gave you are satisfied, then you can grow the monsters if you can find them.
Okay.
Yeah. Okay. And that, in their mind, that was the quid pro quo. To take away medicine, we're going to give you 6 plants. Well, last minute.
But Dale, you don't find them. You grow them from a seed. You don't find them.
Well, but the reason I started this off by emphasizing that you do not have a right to grow more than 6 plants, and the locals can put you inside of a building. Okay. Now, they've tried, Normal's tried, other groups have tried to expand that, but you don't currently have that legal right.
Okay, but it's just like where I live, I can tell you, I cannot even see a neighbor. There's nobody here.
It's not relevant. I'm sorry to tell you, but it makes no difference whether you can see a neighbor. There are rules put in place.
Doesn't it have to do with your, like some people can't grow anything and they try to grow it and it comes out to be this little dinky thing. What if you have a green thumb and they just happen to take off like monsters? What are you supposed to do? Cut them back and throw them in the garbage because the plant wants to grow, 5 feet higher than what, and it's still 6. So you grow 4 plants that are monsters. You're still going to have more pot than in the 200 square feet.
Okay.
So the law really is stupid.
Okay. Well, that's a whole nother webinar.
Yeah.
Okay.
Okay, but you know what I mean.
Well, no, I understand, because when cancer came to my house, okay, the cop showed up, I was growing weed, okay, and it was illegal. And I had to fight. This was starting over 20 years ago. I've been fighting this same fight. I understand. It's frustrating. I've watched friends die. All of us have. And
you might be going right back into the fight again.
Well, I never you don't know where this is going to go. I left the fight when I spent time in the Federal Hilton, but I came right back to it, and there is no clear, smooth path to fix this. Okay.
Yeah, I guess until it's not a Schedule 1 anymore, then it's going to be all different, right?
Okay, let me just make the statement. Because we all aspire to something does not mean it's legal today. Okay.
Right.
I aspire to all sorts of things, but I'm a pragmatist and a realist. If they show up and you're not in compliance, then there's not a lot good going to happen after that. As much as I don't want that to be the case, that's why I'm putting this seminar on, so that we can tell you, here are the rules, and they're going to make you live by them, whether we like them or not.
And Valerie, we're going to go on. We have a lot of questions, so we're going to go on to the next person. Okay.
Okay. Thank you for all you guys are doing. Really appreciate it.
Okay, so we've got Al.
Hi, Dale.
Hey, Al.
I live in a private area in El Dorado County. Where does all that come in, or does it at all?
I don't know what you mean by private area. What does that mean?
Well, I don't know how to put it. It's all the whole. It's like an association, but without an association.
So a homeowners association, sort of?
Yeah, but there is none.
Okay.
It's just a road that goes up and circles around, goes about 3.5 miles.
Is it a private road?
Yeah, yeah.
Okay. Who maintains it? Do you guys have some group that maintains it? How does that work?
People just put patches on.
Okay. I'm just curious.
Yeah.
So
it's not state or
okay.
El Dorado maintained, no.
Okay. So your question is what?
What rights do they have, buddy? What rights do they have to come up and invade my privacy, so to speak?
Well, if they
somebody got to call them and
Nope.
complain.
Nope. satellite can see it. If they see it from a satellite and you're out of compliance, they have now the right to look into what that violation might be.
Okay. So that really plays no part in any of this.
Well, no, I was on a private road and we had what Phil Denny, my neighbor, called a fast funeral come up. 20 SUVs came up the road. Okay, I know, I get it. Okay, no, if you're in violation, they can get an administrative warrant, come up there, and they can go on your property if they get a warrant, or they can come tag it and say we have reason to believe. And the hearings are going to include satellite imaging. That's already allowed to come into any hearing. If they got a picture of you out of compliance, that's a bad starting point for you.
Yeah. Okay. So nothing's changed.
Well, let me tell you, things have changed. Okay, because 20 years ago, I was trying to get this kind of definition for a lot of people that were a lot more afraid than medical patients are today. Okay,
Mm-hmm.
and we've been trying to negotiate and sit down for over 20 years now, trying to get this straightened out. And there were some events that happened. The SB 420 caused a couple of, two cases were brought in the county that the county lost. Okay, and I mean, I'm not going to debate the merits of whether they should or shouldn't be brought. They were lost. And when they couldn't enforce the criminal laws as they thought they were going to, then enforcement kind of took a step back. And it led to what we now have is a dead deputy because someone did a handshake lease on their property with a Mexican cartel. Okay. And that's the reality that we're in. And my goal is to keep people who are sick from being in the line of fire.
Right.
Now, hopefully, we can get enough to go to the board, the next ad hoc committee, and sit down and talk with them and see if we can work out either a further exemption or refine some of these rules, something. That's why I want people to work with their plants, what they're doing with it, how effective it is, so we have ammunition. Because I know what a 20-foot plant makes, but it may cause you anxiety and you can't use it for sleep. I don't know. It goes well beyond that issue. So we have a lot of work to be done, and I'm getting old, dude. I've been doing this for over 20 years, and I'm tired to have to keep doing this. But because it affects so many that are friends of mine, my children, family members, friends. This affects a lot of people, and I'm going to do what I can do to protect people who are sick from being in the line of fire. Okay, but if they show up and you're violating things that we're telling you don't do this, then I don't. It's not fair. It's not right, but it's real and it's legal.
Right.
Okay.
Thank you, Tony.
Okay. Who's
So we're going to go to the Q&A next. First question: if 6 plants were planted after May 6th, are they subject to the 200 square foot rule, or is it just 6 plants unconfined by a space requirement, as in can they exceed 200 square feet?
No. If you start them after May 6th, you get 6 plants per residence.
So the question is, how big can they be? Can they be as big as you can grow them?
There's no restrictions on size. It's number only.
Okay.
And under Prop 64, you get to keep all the products of your cultivating of 6 plants. You got to keep them secure on your property. But if you do get 10 pounds of plant and you produce 60 pounds, okay, you get to keep that on your property, or you can do some processing of it. And that may be a whole nother webinar of what you can do with it. But, I tell you, don't sell it. And especially don't get caught selling it, because that will not go good for you.
Okay, so next question. I have been collecting cannabis stalks for years. I have a large stockpile of it to make hempcrete, Adobe fireproof walls. What are the laws about that?
Well, you need to go to the California Builders Association and get the building codes changed, because right now hempcrete's very expensive insulation. It's not it's not structural.
So
So
to
we got a
clarify,
long ways to go.
if there are stocks just stored on the property, which would essentially constitute waste, is there any reason to believe that it is illegal to just have stocks that could possibly someday be made into hempcrete?
I can't think of, especially now that hemp, 0.3% THC or less is legal. It's unless you got 50 tons of the stuff there, and I don't see that as a problem. No, they're
Okay.
looking for flour, biomass that can be extracted. They're looking for the stocks.
Okay, so next question is about the rules, like from screening and those types of rules. Do these rules apply to people under the square footage law only, or do these things apply to people who are also growing 6 plants only?
It applies to cannabis for personal use, period, whether personal medical or the 6 plants under Prop 64.
Perfect. Okay, next question. How do you work your mother plants with these new rules?
By work, you mean how do you keep them and then take your cuttings off them?
Correct.
Well, be careful with creative math, okay? Because there was a time when we had enough room in the immature plants that we could account for that. And if you have 200 square feet and you can constantly grow 200 square feet, you can have a mother or two and stay within those limits and then make your cuttings and fill up the rest of your 200 square feet. If it's only 6 plants, 6 is a pretty concrete number. And it doesn't say, oh, but you get 2 or 3 mother plants. No, it says you get 6 plants, or they won't enforce against the 2, 4, 600 square feet if you comply with all these rules. So it's possible that this season you could have a mother plant or 2 as long as they fit within the 200 square feet that you get for cultivation canopy.
Okay, so that was all of our plants. Bobby did ask. The ordinance he printed out yesterday says $1,000, not $1,500 per violation first time. When did it go to $1,500?
Oh, okay. Well, we got the version that was slashed in. Have you seen the final cleaned up version as it exists in the ordinance right now, Heather? Because
Yeah.
Bobby's right. If I remember back, and I apologize, when they changed it from 72 to 96 hours, I think they did drop the fine to 1,000. But and I apologize because what we got, and I think what Rod Miller put out this morning on the alliances page, was the redlined version that we got at the last Board of Supervisors meeting, where Bree had carved out the "we won't enforce" section, and you can, if you look at it closely, it's got red lines and blue lines that are crossed out and things like that. So you're right, Bobby. I think it is 1,000, and I apologize for that, but it's a lot. Okay, unless you got a lot of dough hanging around, $1,000 a plant. If you can't feed your kids, it might as well be $1 million a plant. It's a lot. It's a lot.
Okay, so that was all of the Q&A questions. Does anybody have any more questions? Either submit through the Q&A button or raise your hand. Going once. Going twice. I see none. Okay.
Sold American.
Sold American. It is approximately 5:34. So thanks everybody for participating. Oh, yeah. Hold on. Here's we have one.
Is this Tony?
Tony?
Okay.
Yeah, I just want to say, did you guys hear me?
Yes.
Yep. You sound like you're in a hat or something.
Yeah, it's kind of a little cave that I am in. I just want to say thank you guys. You covered it very well. I had a few questions and you just rolled right into it and answered them. So I just want to say thank you and stay in focus and keep up the good work.
Thanks, Tony.
Okay. Have a good evening, guys.
Everybody, relax as much as you can and contact us if we can help you. But follow the rules. They're going to enforce heavily and make you stick to these rules. So that's why we did this. Everyone
Thanks,
have a good
everybody.
evening, okay?